politics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Michael Baranowski, a political scientist at Northern Kentucky University. My guest today is Ohio State Supreme Court Justice Michael Donnelly. He took office in January 2019, and prior to joining the court, Justice Donnelly served as a judge on the Cuyahoga County Court of Common Pleas General Division for 14 years, from 2005 until 2018. Prior to that, Justice Donnelly was an assistant Cuyahoga County prosecutor from 1992 until 1997. He also practiced civil litigation for seven years, representing plaintiffs and injured workers in asbestos litigation, personal injury lawsuits, and workers' compensation claims. And today, Justice Donnelly and I will be talking about an issue that's very important to him, and I think that should be very important to everyone, and that is transparency and reform in the criminal justice process. Justice Donnelly, welcome to the show.
Thank you very much for having me. It's an honor.
So, as I said, today we're going to be talking about the criminal justice process, transparency, really, and specifically as this relates to plea bargains and sentencing. But I thought before we did that, maybe it would be helpful for listeners to get a sense of kind of what it is exactly that a justice on the Ohio Supreme Court does.
Sure. Well, in 2018, I was elected Associate Justice of the Ohio Supreme Court, and we're generally known as the court of last resort in the state of Ohio. I sit as one of 7 elected justices, and we serve for 6-year terms before we have to submit ourselves for re-election for the public. The judiciary, as I'm sure most of your listeners understand, is the branch of government that resolves disputes. And disputes, the vast majority of disputes are going to be resolved in our trial courts. In Ohio, we call the felony court the Court of Common Pleas, and they handle serious felony charges on the criminal end and serious civil disputes as well. And we also have our municipal courts that resolve a vast majority of misdemeanor type charges and smaller disputes on the civil end. So that's generally where a party who is either a plaintiff or a defendant, or the state of Ohio as in a criminal case is bringing charges, and the case is going to be initially resolved there. If you receive an adverse ruling at the trial court level, you have the ability to appeal your decision to one of the 12 districts of Court of Appeals that exist in the state of Ohio, to have your case reviewed to determine whether there was any error that occurred, and make the pitch that the case should be reversed and sent back to the trial court. If you receive an adverse ruling in one of those appellate courts, then you have the opportunity to petition, just like you would at the U.S. Supreme Court, to petition to have your case reviewed by the Ohio Supreme Court. And we, unlike the appellate courts below us, we have discretion in which cases that we bring in for the most part. And with a few exceptions, death penalty cases get directly appealed to our court. But in the vast majority of cases, we are voting. And our criteria that we apply is the dispute a matter of great public importance, or does it involve an alleged violation of the Ohio Constitution or the federal Constitution? That's what we vote on. And if you receive 4 of the 7 justices' votes or more, then the case will be accepted for review. If you don't receive that, then generally the decision you receive at the appeals court stands. But if we take a case in and we decide it, the holding in that particular case will become the law for the state of Ohio, and the lower courts will be bound to follow that. So it's very important, and I'm very privileged to be there as part of the justices who review these cases, evaluate these cases. And also I have an opportunity to have more influence than I did when I was a trial court judge to work on matters that are important to me, and that's criminal justice reform and civil civil justice reform as well.
And I should point out to listeners that this isn't just an Ohio thing in the sense that, I mean, the vast majority of all cases are at the state level, while the federal cases get a lot of attention. Most of the criminal justice system, that all happens at the state level. And so issues about criminal justice reform, even though the focus oftentimes we hear about is federal legislation, really, the states are where we would expect to see, or where we would hope to see, maybe the most consequential reforms happening.
That's correct. There's significant differences between the way the federal courts operate and the state courts, particularly when we're going to talk about this today on how the judges involve themselves in the plea bargaining process in the state system, as opposed to the federal system, where the judges don't really get involved the way they do in the plea bargaining process in the state court.
Yeah, I think we should jump right into that because very recently you had an article published in the Ohio State Journal of Criminal Law, which called Truth or Consequences, Making the Case for Transparency and Reform in the Plea Negotiation Process. And I'll put a link there in the show notes, folks. And normally you'd say, oh, law journal article, this horrible jargon-filled thing. But no, this is totally the opposite of that. It was really a fascinating and a pleasure to read. And so I think it's definitely worth your time. And in that article, you mentioned a line from former U.S. Supreme Court Justice Anthony Kennedy. And I thought it was really interesting. He says of plea bargaining that it is not some adjunct to the criminal justice system. It is the criminal justice system. What did Justice Kennedy mean by that?
I think he was pointing out the reality, what all people who work within the system, judges, prosecutors, and defense attorneys all know, and that is that the vast majority of cases are not resolved, as you see on TV, by proceeding to trial where the state goes before a jury and proves the truth of the charges beyond reasonable doubt. The vast majority of cases in our system, I'm talking nearly 97%, are resolved through negotiated plea bargain. So if you look back, as I say in the article, and thank you for your kind words as the article, I did intend, even though it's in an academic journal published by Ohio State, I'm very grateful to them. I did write it with the intent that it would speak to law students who have no concept of what goes into the plea negotiation process, and the general public that I believe that we serve deserves to understand how the process works. So that was my intended audience, and I wanted to kind of lift the shroud of secrecy that kind of, in my opinion, covers this very often secretive process.
And can you talk a little bit about how, I mean, I know there are a lot of very differences from case to case, certainly, but I would imagine you can maybe make some generalizations about how typically this tends to play out, this negotiation.
Sure. Well, just for an example, in Cuyahoga County, where I work, in Cleveland, Ohio, on average, there used to be about 10,000 felony indictments per year that came out of the grand jury. So that's an accusation of criminal conduct being made by the state. And the first stage in every criminal case occurs at the accused arraignment hearing, where that person is going to be responsible for answering that accusation, either through a not guilty plea or a guilty plea. And 99.9% of the time, as everyone who works in the system knows, that's going to start with a not guilty plea, a denial to the truth of the charges. And there's good reason for that. That's generally the time when a lawyer, if the accused is fortunate enough to have the resources to hire their own lawyer, if they don't, then they will have either a public defender or assigned defense counsel applied to represent them at that stage. And they have not seen any of the evidence that supports these charges. So they're going to advise their client to enter a plea of not guilty. A bond is going to be set at that stage of the proceedings. And then the case is going to be randomly assigned to one of the judges that works in that jurisdiction. And once that takes place, then the way every single trial court judge moves their docket towards resolution of these disputes is they provide every case with a firm trial date. And that's that's the fuel, so to speak, that moves the system along.
Right.
Because once a trial date is set, parties, the accuser, the government, state of Ohio, has the burden of preparing their case and sharing all the information. We have open discovery in the state of Ohio. We did not have that always, where the prosecutor is required to turn over everything in their file. As a young prosecutor, I was not required to do that.
Wow.
Until 2005. We had, around that period, changed our rules, and now the prosecutor is required to turn over all the evidence that supports these charges, witness statements, police reports, videotapes, whatever they intend to use, should the matter go to trial, needs to be turned over. And that includes what we call Brady material. Any evidence that is exculpatory, doesn't fit in line with the theory of guilt that they plan to present. They have to turn that over to the defense for their evaluation and consideration. And the defense has to prepare as well. Both parties know that on that trial date, the judge is going to expect one of three things to happen. Either the prosecutor is going to go forward, we're going to call up a jury, and they're going to be held to their burden of proving the truth of those charges beyond reasonable doubt, or the court is going to dismiss the charges if they have no good reason why they're not prepared to go forward. That's the power of the court to move the docket. Or the parties are going to present to the court what is known as a negotiated plea agreement governed by our criminal rules, Criminal Rule 11, when the parties have negotiated a contract, so to speak, that completely resolves the dispute. So that's an overview about every case, no matter how serious the case is, murder case, rape case, all the way down to low-level drug dealing. That is the process by which these charges get resolved. In 97% of the cases, it's a negotiated plea agreement.
And that negotiation, that's typically, right, an informal, not on the record process. And based on my reading of your article, you think that there's a problem or some problems with doing things that way, right?
Yes. When I started as a judge in 2005, I began to study the plea negotiation process from a new perspective. Now I was no longer an advocate as I started my career as a prosecutor. I was the neutral in the process. And when I became a judge, I engaged in the process of plea negotiation the same way I learned as a prosecutor, and in a manner that I never really questioned until I was in this new role. Pleas often get negotiated in private between the prosecutor and the defense counsel. However, as I mentioned at the start of the show, in Ohio, the judges get involved in the plea bargaining process because once a tentative plea agreement has been negotiated, the next step is that you have to go before the particular judge where the case is assigned and see if they will accept the plea agreement as negotiated. And in my article, I describe what I believe is a systemic flaw in the way the system operates, is in the fact that there is very little guidance that guides trial court judges on whether to accept a plea agreement or reject the plea agreement. They have huge amounts of discretion in this regard. There's very few cases where judges who have rejected plea agreements and that issue has been appealed to the appellate courts, they apply on what's known as an abuse of discretion. Two out of three judges would have to agree that the judge abused their discretion in refusing a plea agreement. It's a very high standard, and the appellate courts are very deferential to trial courts' decisions in this regard. And as a result, among the hundreds and hundreds of common pleas trial court judges, and I was one included, there are different philosophies that exist that I think we need to talk about and the public needs to be aware of, because the fact that they exist, in my opinion, results to a lot of disparate treatment from courtroom to courtroom. And just for an example, and during my 14 years, I always viewed myself as the neutral in the process of plea bargaining. So when the parties came to me and presented what was an arm's length negotiated transaction, what I mean by that is both sides were zealously representing their clients. There was no type of sweetheart deal taking place. And they presented a case, and oftentimes they would present agreed sentences. We think the appropriate sentence here is agreed probation. We think that it should be an agreed minimum prison sentence. This is why. And I always was amenable to those types of agreements because I viewed myself as the neutral. The parties knew more about the facts of the case than I did, the procedural hurdles they were facing should the matter go to trial. So I always accepted that. And likewise, I was granted a lot of discretion in sentencing. For 14 years, I had plenty of opportunities to go above, that is, sentence someone more severely than the prosecutor was asking for. And in 14 years, I never did that. I never saw why any guidance in the law that would direct me to do that. But some of my former colleagues on the trial court, they possess different philosophies. They think sentencing is totally within their realm, and they will let the parties know that they retain the discretion to go above even what the prosecutor is sentencing someone to. So a lot of these negotiations take place in judges' chambers outside of the presence of court reporter or the press or the public or the people involved in the case. And so practitioners in the state of Ohio have to navigate among all these different philosophies that exist of judges on the trial bench. Some judges will, for instance, make representations off the record about what they're inclined to do at sentencing. But they don't, there's unwritten rules that exist in these judges' courtrooms that even though they're making these representations, that no one is to say anything on the record until the actual sentencing date. So in these judges' courtrooms, what takes place, believe it or not, is the defense lawyer has to go out and say, great news, I just had a discussion in the back room and we got you a minimum sentence. We're going to go in and we're going to do a plea hearing right now. However, when the judge asks you the question, has anybody made any representations to you about what sentence you would receive? Your answer should be no. And that's often confusing to the client. Well, what do you mean? They said that I get a minimum sentence. But they don't want this being said until after the pre-sentence report. And you have to, hope that the judge remembers that representation and basically doesn't go back on that promise that was made in the backroom discussion. So that's one different form of judicial philosophy. On the other end of the spectrum exist judges who won't tell you what they're inclined to do for sentencing. So you have this negotiated benefit. It's supposed to be a benefit where the state is receiving a resolution to the case without going through trial and using the resources that they need. The defendant is getting a resolution, and what the benefit that they are seeking is some degree of leniency in the consequences that are going to take place should they enter this plea. And in these judges' courtrooms where they won't make that representation, it's my argument that they're not getting so much a negotiated benefit. They're getting the hope of a negotiated benefit, and they got to hope at sentencing that takes place. But sometimes people who enter these plea agreements, I call this sentencing by ambush, where the prosecutor doesn't make any representation about what they intend to advocate for. They drop half the charges in exchange for plea to other charges. And then the defendant shows up at sentencing not completely unaware of what their consequences are going to be. Some defendants show up thinking they're going to get either probation or a minimum sentence, and they receive sometimes decades-long sentences at sentencing, and they walk out of the courtroom shell-shocked and questioning what benefit they gained from entering the plea agreement in the first place.
Wow.
So we have all these different areas, and you can see how that when these different philosophies operate, you're going to have disparate treatment of individuals for the same crimes or similarly situated crimes from courtroom to courtroom because of these philosophies and the fact that we've never had a discussion as a profession on what the judge's role should be in the process.
Wow. Yeah, that really surprised me because I always just assumed that once that decision was made, it was just the formality for it to happen in open court. And so realizing that just really surprised me, dismayed me also. And, another thing that kind of, I don't surprise me so much, but the existence of what you call legal fictions. I would think, or I think a lot of people might think that one thing that a judge wouldn't allow is for somebody to plead guilty to something that they actually didn't do and that everyone knows that they didn't do, because that would seem to subvert the whole idea of the justice system. You could argue that at least, but that's not really the case, is it?
That's correct. The process of resolving cases through legal fictions, which are more commonly understood by your listeners as lies, takes place more frequently than one would expect. And it involves a process that the parties allow the defendant to resolve a case by pleading guilty to a charge that in no way resembles the original charges that were originally initiated against them. And we tried to change this practice. This is a practice that's outlawed actually in the federal system. They require what's known as a factual basis for every charge. There have to be facts that, if true, support what the defendant's about to admit to resolve the case. And a number of states are moving in that direction. In 2016, before I joined the court, I was involved with an effort that was endorsed by the Ohio Judicial Conference to change that Rule 11. That would require that every plea have a factual basis. And I had this policy for over a decade. In my room, I let the parties know that I would never accept a plea that didn't have facts that, if true, would support what the defendant would be pleading to. It's contrary to the tenets of our justice system that we try to achieve in every case, and that's truth and integrity of the process. It's not fair to the accused, and it's not fair to, if the case involves a victim, the alleged victim in the case. So we tried to change that, but there were a lot of opposition from individuals, even though we had a lot of support from ethics professors across the nation, editorial boards. There was a lot of internal pressure, I think, with the court, and we ultimately rejected that. And there's a Columbus Dispatch article you can Google, and the headline reads, "Ohio Supreme Court rejects truth in sentencing." I think is unfortunate. So I'm hopeful that we will address this problem. That this, because we're doing in backroom discussions, we're allowing these pleas, and they reflect resolutions that a jury could never find if they were considering the case. And we're putting false information into the system. And the public, in my opinion, has a right to believe that the outcomes of our criminal justice system are based in truth and based in fact. And oftentimes that's not taking place in a lot of cases.
It seems to me that there might be a fairly big incentive for prosecutors to do this, right? Because if you have a better conviction record, well, that makes you look better potentially for promotion and other things like that. And so maybe there might be some problems with an incentive that pushes prosecutors to do and agree to things like this.
Yes, prosecutors are under, I think, a lot of pressure because of the volume of cases that they're dealing with, especially in a major jurisdiction like Cleveland, to resolve cases short of going to trial. Not every case can proceed to trial. We just don't have the resources to it, nor if the major facts are not in dispute, the trial really becomes unnecessary. But you're right. I mean, I think prosecutors are elected officials just like judges are in the state of Ohio, and they want to demonstrate that charges they bring ultimately result in a conviction. And I think that looks good when you're running. But I think also public perception of the prosecutor's role is changing. I believe that throughout the country, jurisdictions are electing what are being referred to as progressive prosecutors, who really believe in the notion that prosecutors, their role is not necessarily to seek a conviction in every case. Their role is to seek justice. And if they don't believe that the evidence that they have, if they can't form a good faith belief in the guilt of who's been accused, then I think we need to have rules in place that give prosecutors the fortitude to dismiss cases and not be afraid of having the fact that they dismiss cases that don't meet that high standard, that they don't feel confident they can go into court and prove beyond a reasonable doubt, dismiss cases. Or if you're going to plead the cases, you have to plead them to what I explain in my paper, what are known as lesser included offenses. All serious crimes, the legislature have given judges and prosecutors and defense lawyers tools where you can plead cases down to what are known as lesser included offenses. They carry less penalties, but they still retain that factual basis because if the defendant in fact, in truth, committed the more serious charge, then they also committed the lesser included offense. I'll give you an example of that. The charge of rape. I've tried many rape cases and presided over many rape cases. Those cases can be very challenging for prosecutors because sometimes it boils down to one person word against the others, and they can plead the charge down to a crime known as gross sexual imposition. It still retains a factual basis because if in truth they committed the more serious charge, they also in fact committed that lesser included offense. And so the defendant gets a benefit of whatever leniency that lesser included offense will provide in the sentence. And the prosecutor is able to get closure by resolving the case and getting some level of accountability for the victim in the case as well.
Now, you're not just talking about this as a sort of theoretician. You actually, and I really like this, the fact that when you were a trial court judge, you actually changed some procedures, I think in a pretty significant way in your court to kind of address some of the issues that you saw. And I was wondering if you could talk a little bit about what you did as a trial court judge.
Sure. I describe this in my article as probably the biggest epiphany of my legal career. When I started to study the way plea bargains were being negotiated and sentences were often being finalized back in my chamber during my first term of office, I began to question the ethical nature of this because, we're talking about something that, if it's accepted by the court, is going to most likely profoundly affect the accused's life in certain ways. They may be going to prison for a certain amount of years, or they're going to have restrictions placed for a number of years on their behavior. So it's profoundly affecting the life of the accused. And also, if not all criminal cases involve cases that involve victims, but certainly a significant do. If there's a victim in the case, they are being left out of the conversation. So one day I came to the conclusion that no one should ever say anything back in chambers off the record, including the judge, including myself, that you wouldn't repeat verbatim. So one day I told my bailiff, I want to change the process in which I engage with the attorneys. And we can have the same discussions that we've been having back here, but we're going to just do them out in the courtroom with the court reporter out in open court.
Wow.
And I did that. I'll never forget the day I started. The revelation to me, because when you put people on the record, you focus on the merits of the case or the lack of merits. Attorneys, judges don't want to embellish or tell falsehood when you're placed on the record. or represent facts that can't be supported. And no one wants to appear coercive or threatening. And there's a lot of coercion that takes place in the plea bargaining process that people don't know about due to the various tools that the legislature has provided prosecutors and courts through legislation that add a bit of coercion, not a bit, significant coercion to the process. And so I started, we had all our discussions on the record. And if the parties wanted to delve into sentencing, I would first ask what the state was planned to advocate for. I really believe in a fair system. The defendant's going to enter a negotiated plea agreement. They have the right to know at that negotiated plea agreement what position the prosecutor is going to take 30 days down the road at sentence. They shouldn't be surprised by that.
Right.
If the prosecutor is going to be advocating for a severe prison sentence, they should know that if they're entering a plea agreement at that particular point. So I always made it a process of asking the prosecutor, what do you intend to advocate for? Sometimes they'd say, we're going to leave it to your sound discretion, Judge, or Judge, we have no objection to probation here. And then I would turn to the defense lawyer and I would say, what are you going to be advocating for at the sentencing hearing? And they'd say, we're going to be advocating for community control, what we call probation in Ohio. And I'd say, well, do the law and the facts support that? And they would make the argument. They'd say, yes, you just saw that the felony of the first degree was just reduced to a felony of the fourth degree or fifth degree. It has a legal presumption for probation. My client is working. If you were to send him to prison, which is well within your discretion, it would totally destabilize their lives. They would lose their job and their ability to support their family and the ability to make restitution to the victim in this case. And we believe that he can be all the goals of our sentencing laws, which are contained in Ohio Revised Code 2911 and 292912, which are the cornerstones of our sentencing scheme in Ohio, where judges are supposed to be thinking about in every sentence, what is it going to take to adequately punish the offender, set them on a course towards rehabilitation, provide protection to safety to the community, using the least amount of our limited resources possible to do that. That's what should be going through every trial court judge's sentence, no matter what it is, when they come to that conclusion. And the process of doing it on the record provides, I think, a means where everybody involved in the case can have confidence that everybody's doing their job right. That transparency where the public is able to discern that the process is operating correctly.
And how common is that sort of that level of transparency in your view and your experience, the sort of thing you did?
I don't think there was anyone else that did it much on the record.
Yeah.
And a lot of judges will do this. They will have the negotiation on record, and I think they feel the same type of uncomfortable feeling that I had, and a lot of judges will reiterate what was just said in the back room for the defendant. They'll say, "We just had a discussion, and this was what was represented, and this is what I represented." And I took that step out of the equation. I said, "Why go through that from an efficiency point of view? Why not just do everything on the record?" So that way. If I make a representation as to what sentence I'm going to impose, what I would often say is, well, let's get a pre-sentence report investigation from the probation department. If everything that was represented here today is correct, this is what I'm prepared to do at sentencing. And then you kind of see the defendant, you'd sense a sense of relief that I made that representation on the record. Because once I did that, as long as everything that was represented was truthful and was supported by the facts in that investigation that was going to take place, then I was held accountable as the judge. If I was having a bad day, 30 days down, or for some reason I'm in a bad mood, and I don't get to go back on the promise that I made, which actually worked as an inducement towards the accused, and That way, it's more transparent, and it provides public confidence that the system's working correctly.
Now, I think what some people might say is, yeah, transparency is great, but if you make a system thoroughly and totally transparent, it makes it harder to, you might say, grease the wheels, I guess. You have a little less flexibility, and it's good to have the opportunity to apply that, you use the term in the article, rough justice, if the alternative is potentially, no justice at all. I was wondering what you thought about that, because you certainly have heard that objection.
Oh, yeah. When we tried to propose the rule that we did, there was some very thoughtful insight, particularly from the criminal defense bar, that was worried about moving in this direction. And, they'll say we need, because of the laws that exist, what they often describe as draconian laws that tie judges and prosecutors and defense lawyers' hands when they try to negotiate what they believe would be a just resolution, that they need that flexibility and creative. They call it creative, but when they result in legal fictions, I don't think it's doing anybody system any good. I don't think it's fair to the accused. If they are truly not guilty of what they are charged with, then they're being offered oftentimes something that is so coercive that even if you're innocent, very well-known judge that I've become friends with over the years, Judge Jed Rakoff from New York, who has written many articles on plea bargaining and other aspects. He wrote a great article that was published in the New York Review of Books called "Why the Innocent Plead Guilty." And you can see in some of these pleas that result in legal fiction that the parties rationalize in their own mind they're forming some level of justice because you're going to get control over the defendant, even though he's pleading to something and admitting to something that is totally just not true, and everybody in the room knows it. You question why people would ever think of this resolution justice. It's not justice for the victim. And it's not justice for the accused. The truth is the truth. Either the victim is telling the truth or they're not. And the defendant who's representing that they're not guilty is either not guilty or they are. So the truth is that the system is designed to get at least some level of accountability, and that's what we look for in our justice resolutions. And people rely on the outcomes of the criminal justice system for a variety of things that we need to protect the integrity of these resolutions. Employers in our community do background checks on people that they investigate. And so they want to know that if they see an offense, that there are facts that support that offense. They don't want they don't want to find out later that it was some legal fiction that they swept the case under the rug. Police doing their investigation need to know about someone's truthful criminal record. Sentencing judges in the future, one of the most important things I looked at when I made a very important sentencing decision was what was the individual's past criminal record. And I would use that to make a very important decision. And oftentimes it meant the difference between incarceration and probation. So there's all sorts of policy reasons that we need to believe that these outcomes reflect the truth, right, and some level of accountability for the criminal conduct that actually occurred.
Well, I couldn't help in reading this and thinking about this issue a lot more. Think of for instance, without getting into details of the case, the Michael Flynn situation, right, where where people saying, well, he said he was guilty in open court twice, and so either he is or he perjured himself, without getting into the Flynn case itself, you can make the argument, well, oftentimes it's not as simple as that. There's all this other stuff going on that sort of you've been talking about this whole time.
Yeah, I mean, that case has caused quite a bit of public controversy for a variety of issues because, over the course of 14 years, I had many requests to vacate pleas, but they often came from defendants who
Right.
said, they didn't believe that they thought they were coerced into the plea agreement and they wanted to exercise their trial rights. And we'd have hearings on that. Very rarely would you ever get a motion to vacate a plea from the government.
Yeah.
And I think that's why people are calling for a hearing. Why did someone plead guilty, and why is the government taking this unusual step in the Flynn case to have those charges vacated when there's been certainly defendants across this country that didn't have the resources that he did in defending him that have led to similar cases, and there's been no motion from the government to vacate those charges, and I think that's very troubling, especially to people that work in the federal system. And the Flynn case is a great example of what I've talked about in my article about the criminal sentencing database and why we need to have every single sentencing and what sentence is imposed in every single case needs to be collected, including all the data points regarding that particular conviction, including the race of the individual, the person's background. It's just absolutely necessary to advance our system and make it a more fair system. And that Flynn case is a great example of that. When he, I'm mistaking it about the Manafort case.
Right.
So we can talk about that. But, the Flynn case is that brings up transparency, and what I would do if I were the trial court judge in that case, I would hold a hearing and I would hold the government accountable to provide reasons on the record why they are doing what they are doing, right, so that the public can have confidence that no one's getting any type of special treatment.
Yeah. And you mentioned the database thing. I got to say, when I read that, I thought, wait a second, you mean there's not already a database where you can look up the sentence for every sort of crime and get averages and that seems to me to be the most sort of straightforward, obvious thing that every state and the federal government would have, and the fact that that isn't the case really just stunned me.
Yeah, we have been clamoring ever since the sentencing laws that we currently operate in Ohio. They contemplated that we, as the judiciary, would eventually collect this information so it would be useful to judges, prosecutors, and defense lawyers, especially because the laws require trial court judges to issue similar sentences for similarly situated defendants. But there is really no resource, centralized resource, where you can collect that information statewide. Lawyers have, on occasion in certain jurisdictions, been able to go into their own research, but it's often so time-consuming, so laborious that defense lawyers in the state of Ohio, you just do not have the ability, based on the volume of cases, to do that, and that's just wrong.
Right.
In 2002, a task force studying racial disparity in outcomes of our system called exactly for what we're advocating for right now, the creation of a centralized database. And they put together a great report, and it went into a file somewhere and gathered dust, and we never followed through on the implementation of collecting this data, which is so important. And I think the recent events that have taken place across the country has provided that momentum, because there's a vast portion of our population that don't possess the confidence in the system. They believe that the outcomes are disparate treatment, and the only way to demonstrate this is by providing the data. A couple of years back, your listeners should Google Florida's broken sentencing laws. And a newspaper down there, some investigative journalists did a great job, and they studied the results of sentences that were coming out in similarly situated cases. And what they found was very disturbing, that people of color were being sentenced to much more severe sentences than the white population that was being sentenced for the same types of crimes with similar background. And that's what sparked their call for a database. And if I could just touch base on the Manafort case one more time, that case caused a national conversation on why did he get just 47 months when the government was asking the judge to impose 19 years.
Right.
And so I studied that case to find out just exactly why. And what I learned was that the defense lawyers in that particular case, they were armed with the information that our lawyers in the state of Ohio do not currently possess. They were able to say, wait a minute, Judge, on the record, before you go and impose this 19-year sentence that the government is asking for, we want to show you, here's 17 cases, some of which were your cases that involved defendants that pled to the same thing. Some of these cases involve more money being transacted, and this is what you impose. And the sentence were vastly lower than what the government was asking for. And so the judge was forced, on the record, when presented with that, he did not want to treat this defendant. He could not find good reason to treat this defendant differently than those people were treated. And so I think that's what would occur. I'm very confident that would occur in our system if we had that. Trial court judges, when you're issuing a sentence in the state of Ohio, you're often, in my opinion, shooting in the dark as to whether your sentence is going to be consistent with similarly situated cases. Unlike the federal system, where they have these guidelines that are supposed to promote uniformity between courtroom to courtroom, in the state court, we do not have those type of guidelines. Trial court judges are invested with vast discretion and power to issue sentences. And there's some guidance, based on the level of the offense. Felonies of the first degree and second degree all carry with it a presumption in favor of incarceration. Likewise, the lower level felonies have a presumption that the parties can rebut. So that's some level of guidance. But in an Ohio court, a judge can, in certain situations, impose probation for what the convictions involve, or they can provide decades-long sentencing. We reviewed a case at the Ohio Supreme Court during my first term where the defendant showed up, a theft-related case of a 55-year-old woman, and she pled to what she thought when she was receiving a benefit. She had half her cases dismissed. And the trial court judge retained the power to give her probation at her sentencing hearing. And she showed up, and the state advocated for 42 years. The defense advocated for probation, and the trial court judge issued a 65-year sentence.
Wow.
So that's an example of the vast amount of power that the trial court bench is instilled with. And, in order to use that power effectively and in a way that the public expects, I think we need this criminal database to be able to monitor every single sentence, and we're able to make meaningful comparisons between different cases, and it would allow the advocates to do what they did in the Manafort case on a daily basis. Is what should be done, and it would provide our appellate courts. Oftentimes, our appellate court judges in Ohio will receive a case, and they're arguing, we want the sentence reviewed because we don't believe the record supports a sentence as drastic as was issued in this particular case. And our appellate court judges in the state, they've told me this directly and through their opinions, they feel like their hands are tied. There's a certain notion that under the laws, appellate courts, while you can review any other aspect of a trial court judge's decision, evidentiary rulings that they made during trial, motions to suppress that they ruled on before the trial went forward. While those are all fair game for our appellate court judges, there's this inherent belief that sentencing is off limits. And they see oftentimes sentences that they believe are totally way out of whack with what, or totally disproportionate to what other people have received, but they feel like they are unable to address that. And I think our system has to have more guardrails in place in order to address the problem of disparate sentencing and disproportionate sentencing. I think it's a real problem, and on a daily basis, it threatens the public's confidence that our courts are operating correctly.
And I would expect, in terms of, for instance, the Manafort example, the existence or having something like this, it actually would have the most important effect for the people who can't afford the hundreds of thousands of dollars to get a legal representation. Where you have, some overtaxed public defender or something like that. Those are the folks who aren't going to be able to marshal that sort of evidence and make that case as the Paul Manaforts of the world can do.
Oh, yeah. The vast majority of our criminal defendants in the system are indigent, and they require the appointment of either public defenders or assigned legal counsel, and the resources are just not available to them to do that. And I was speaking with a Columbus criminal defense attorney who was fortunately retained by a defendant. Same type of example. She was representing someone who was accused of providing heroin that had a deadly dose of fentanyl to a friend. They were both heroin-addicted individuals, and the friend unfortunately died, so the defendant was charged with involuntary manslaughter. So the defense lawyer who I was speaking with, she found out that the state intended to advocate for 13 years at the sentencing hearing. So she engaged in about 25 hours of work over scouring the court's records to find similarly situated cases in not only that judge's courtroom, but other courtrooms. And she put together a great sentencing memorandum that outlined that the sentence that was being advocated for was just way out of proportion to what other people have been sentenced to in similarly situated cases. And it forced the trial court judge to acknowledge this reality, and she was able to effectively advocate for a sentence that was much more proportionate to how other people were treated in our system. And that type of transparency, I think, will promote public confidence. But I've always said that public confidence is diminished when there's a belief among our citizens that the outcome of your criminal case is more in tune or more in line with which judge you are assigned at the arraignment room, rather than the rule of law.
Right.
The application that and the requirement that sentences be fair, that they be proportionate, and meet those overall sentencing factors that are placed in our law for good reason. And if the public believes that your fate is sealed at your arraignment when you get Judge A or B, maximum John or maximum Jane, then I think public confidence goes way down in our court system.
So one final question for you. How optimistic are you that these changes that we've been talking about, that they will, at least to some extent, be implemented in the near-term future?
Well, the fact is, the tragedy that took place in Minneapolis, it's unfortunate that that's what had to take place to spark a national conversation. And I think it goes way beyond people's involvement with the police and charging authorities. It goes throughout the entire system. And I think the massive protests that are taking place across the country and the demand for change and the demand for reform has provided what wasn't there before, the power to keep these issues in the public eye and once and for all implement more transparent measures, ways that are that will act as a check on the system. And we need this transparency more than ever. The press, the watchdog of the elected officials, the fourth estate, they're changing. When I started my career way back in 2005, we had a beat reporter from the daily paper. And when they were walking around from courtroom to courtroom to potentially dig up stories, you wanted, as a judge, you wanted to be on your best behavior,
right?
Because you wanted to be portrayed in a fair manner. That doesn't exist anymore in terms of having beat reporters that cover. They often cover just only the most salacious of cases, and you'll see that on your nightly news. The one, but as far as real in-depth investigative reporting on systemic issues, you just don't see that anymore. So that more than ever, we need a really good raw data to make decisions, and our legislature needs that. You can't make policy decisions without good information. The whole system, runs on good information. When I conducted a sentencing hearing as a trial court judge, I would never go forward on a sentencing unless I received a pre-sentence report that provided me with all of the background information I needed to take into consideration that was relevant to that particular individual's sentence. And every good conscientious judge would agree with that on the trial court. We have great judges across the state. And I think most of them, when you think about what we're proposing, I think they think it will be a good thing. It'll be a tool for them to keep themselves in check, keep your own. Every judge on the trial court is a human being. Every human being possesses implicit biases, and you need a tool like what we're advocating for to keep those biases in check and make sure that they don't come out in your treatment and in your sentencing decision with the people that come before you.
Yeah, absolutely. Well, I certainly hope you're right that this will, some good, specifically this will come out of what's been happening, and I appreciate the efforts that you are making to try to bring that about, and I really appreciate you taking the time to talk with me today.
It was an honor to be here. Thank you so much for the invitation.
That's it for today's show. We hope you like what you heard. If you'd like a second full-length Politics Guys episode every single week, as opposed to just these occasional interviews, you can get that by becoming a Patreon supporter. Supporters also get ad-free versions of every episode, as well as other good stuff. To get the details and to become a supporter, just go to patreon.com/politicsguys. And if you can't afford to become a supporter, email me at mike@politicsguys.com and I will get you full access to that second episode every single week. And if being a monthly supporter is too much of a commitment, but you still like to help us out occasionally, you can do that too through PayPal. You'll find a link on our website, politicsguys.com/support. If you haven't already subscribed to the show, that is a big help, as well as leaving ratings and reviews, and especially sharing your favorite episodes on social media. That's a big deal to us. And if you've got a question, comment, correction, gripe, or whatever, you can reach us at mail@politicsguys.com. For more great discussions, check out our Bipartisan Politics subreddit. You'll find the URL in the show notes. We've also got a Facebook page. That's facebook.com/politicsguys page. And we're on Twitter @politicsguys. The executive producers of the Politics Guys are Bruce Johnson, Wilma Moreno, Andra Masker, Daniel Toe, and Chris Wilkerson. Today's show was produced by Michael Baranowski. We'll be back with a new show next week. We hope you'll join us.